Ladies and gentlemen, we are now coming to the end of the program. The final plenary session is on current and future issues for competition enforcers. Now, please join me in welcoming moderator of this session, Ms. María Canedo, Council Member of Spanish Competition Authority. Ms. Canedo, you have the floor.
Okay, it's up. Okay, thank you very much. Well, first of all, good afternoon, everyone. We are going to begin our last panel, and I want to begin thanking, of course, the Japanese Competition Authority and the ICN for this invitation. It's an honor for me to be here and to share this panel with these distinguished speakers. I am going to explain a little bit how we are going to develop this panel, okay? Because as you have seen, we are going to talk about current and future issues for competition enforcers. And we are going to divide our session on different topics. I don't know if we could have the slides, please, because considering that this was the last panel, we have introduced lots of pictures in our slides in order for you not to get sleep, those of you that have jet lag especially. So we are going to, to divide our session in those topics. We are going to begin talking about energy, then we will continue talking about digital markets, and we will cover in the last part of our session different topics that our agencies have identified, okay? So let's go first beginning with energy. And for dealing with this topic, we are going to count on the interventions of the Mexican Competition Authority, COFECE, and the Portuguese Competition Authority, and of the Spanish Competition Authority, where I will also explain a case. Let's begin first with José Manuel Haro, which is the head of the investigative authority of COFECE, of the Mexican Competition Authority, and he will explain some situations in 5 minutes. Thank you.
Thank you, Pilar. First, I want to thank to the JFTC for organizing this workshop. It's an amazing city. Actually, I have a really interesting anecdote here that relates Japan and Mexico. A president, maybe 100 years ago, had some kind of interest on cherry trees and cherry blossom here in Japan. And for that purpose, I guess that maybe the weather conditions weren't appropriate for the cherry trees. He hired an architect from Japan named Tatsugoro Matsumoto, and at the end the decision was to plant a very famous tree in Mexico which is called jacaranda. So we don't have cherry blossom, but we have jacaranda blossom, which is the equivalent for Mexico. It's really impressive these days, since all the city became purple. So eventually, if we have an ACN meeting, maybe you could see this show. I am happy to be sharing this panel with you, and I do think that it is healthy sometimes to share a different experience from other markets, different from the digital sector. Actually, something curious about this is that many of the issues that we are facing lately regarding digital markets are issues that occurred many years ago with the energy sector. I mean, the energy sector have present several characteristics that are pretty similar to the characteristics of digital markets. For instance, we have scope, we have network effects, we have scope economies, maybe we have a competitor controlling an essential facility that could be considered as a gatekeeper. So maybe I am going to say something that could be considered as controversial, is that in the past, many of these issues were figured out with new institutions that are called regulators. So This is controversial since we are in a competition workshop, so eventually we should think a little bit more about this, the relationship between regulation and competition enforcement. So in this way, in the case of the Mexican experience, we have a lot to share regarding the energy sector. First, I have to say that the sector has changed a lot lately since in the past, I guess that I have to bring a little bit more of context about our Mexican industry. But 10 years ago, our industry was highly regulated. The sector wasn't open to competition. And we have a strong presence of state-owned companies that they were the only allowed to produce electricity or to supply all products. So also we had this infrastructure such as pipelines or storage facilities that were linked to these state-owned companies. So and finally, regarding the retail market, I would say that all the prices were controlled by the government. So it was a hard scenario in Mexico. I have an indicator that it's a good sample of the lack of competition in Mexico. In the case of Mexico, we have a storage capacity for 3 days of consumption of all products. And the average in the world is around 30 days. There are jurisdictions in which you're able to store 60 days of oil products. So this is a concerning issue because due to the lack of competition, we have this kind of characteristics in our market. So 10 years ago, the government decided to open these markets to competition. And we follow some rules that are really important considering our context. First, we establish open access to the pipelines and the storage facilities in order to generate equal opportunities to compete in the market. We had asymmetric regulation for the state-owned companies, which is something very important, and maybe that is lately the spirit of this regulation to the digital companies. And something that it has been pretty useful is we have been monitoring the performance of the market. I have to say that COFECE has been very active monitoring these markets since there are a lot of opportunities to, only 2 minutes to finish. I have to say that we have many investigations related to these efforts of monitoring the market. And we have a couple of procedures related market investigations that I will be talking in a little bit more. But in general, as a final thought, I would say that sometimes I had the feeling that we should look for the past and take some lessons from these processes related to the energy sector. Maybe that could be useful for the future, especially when it's about regulating tech companies.
Thank you. Thank you very much. And now I will give the floor to María João Melícias, which is a member of the board of the Portuguese Competition Authority that is regrettably not with us today, but she will intervene online. Hello, good, very early morning for you, I guess, María João.
Yes, indeed. Thank you, Pilar, and good afternoon to you and Bidyadhar, José Manuel, and everybody in the room. Congrats to the JFTC for organizing this workshop. Indeed, I wish I was there in person, but my presence was required this week in Lisbon. It's 6 in the morning, so I hope my reasoning sounds consistent. It's I suppose my deserved punishment for not being there with you guys now. So I will start by addressing a couple of our recent antitrust cases in the energy sector. They're a bit dense, particularly for this time in the morning, so do bear with me. The first case concerned an abuse of dominance by our electricity incumbent, EDP, for capacity withholding, so a form of output restriction in the market for regulation services in Portugal over a period of 5 years. We imposed a fine of 48 million euros, which was fully upheld by our competition court last year. so both on the merits and the entirety of the fine. And currently the case is pending in our Lisbon Appeals Court. Let me take you briefly through the details. The relevant market concerned the provision of secondary regulation services. These are ancillary services that balance the energy supply from power plants with demand. So they ensure that consumers always have available the electricity they require. And in Portugal, the demand side of this market is comprised by only one buyer, which is the transmission system operator, whereas the supply side includes electricity provider, which hold power plants that are equipped to provide these secondary regulation services, also known as tele-regulation services. How are prices set here? Every day, the system operator organizes an auction for purchasing secondary reserve band for every hour of the following day. Electricity producers submit bids indicating output and prices. So the selling price will be the equivalent to the price of the last bid that satisfies demand in that auction, and it will be the same for all units. And we concluded that between 2009 and 2013, EDP was clearly dominant in this market for secondary regulation services, holding market shares in terms of installed capacity and production exceeding 80% and 70% respectively. Another important aspect of this case was the state aid regime from which EDP benefited, which was a stranded costs mechanism. So it consisted of a public compensation granted to the generating units that agreed to an early termination of the power purchase agreements, which were in force before the market was liberalized, and according to which they received a fixed rent. So the state aid scheme was meant to force the transition into the liberalized market already in 2004. In exchange for an earlier termination of the fixed rent contracts, the relevant power plants were paid for a temporary period as if these contracts were still in force. So if the revenues generated in the market failed to meet that threshold, EDP would be compensated for the difference. EDP was the only provider with a portfolio of power plants that included generating units under this state aid scheme, together with units that were market-based. And this was a key element for the finding of abuse. We concluded that EDP's strategy was twofold. So between 2009 and 2011, it did not bid most of its units that were covered by state aid. So it materially withheld its capacity. And between 2012 and 2013, it actually submitted bids, but at prices that were so high that they were excluded from the auctions. So we found here a form of economic capacity withholding. And this allowed EDP to divert demand from its power units that were already being compensated through the fixed rent state aid scheme to its open market units, thereby obtaining higher revenues from the increased production of these plants. Needless to say, as a result, electricity prices increased, and we estimated a negative impact of at least 140 million euros of overcharge. Our findings were supported by a number of economic studies. Don't worry, I won't go there into detail, but they were supported also by empirical evidence, of which I would just highlight the following, which was the observation of EDP's behavior in relation to a specific power plant, because it sort of provided a powerful natural experiment. During the relevant time frame, this unit had operated under the state aid mechanism, and once the fixed payment contracts were terminated, it also operated under the market regime. And EDP's bidding behavior for that unit during regulation services auctions was substantially different depending on the applicable economic regime, both in terms of prices and output, leading EDP to withhold capacity of the exact same generating unit while it benefited from the state aid scheme. In short, from a policy perspective, I think this case is noteworthy for a number of reasons. First, because we pursued a case as an exclusionary abuse. Not as an exclusionary abuse, but as an exploitative abuse in the form of capacity withholding. That is the limitation of output or production within the meaning of Article 102B of the Treaty on the Functioning of the European Union, without showing that the resulting prices were excessive. And this assessment was totally upheld by our competition court, without the need even for a reference to preliminary ruling to the European Court of Justice, which have become more common in Portugal lately. And since I'm mentioning DCJ, let me just add a final point, because just last week we received encouraging news from the ECJ. Advocate General Rantos published his opinion in relation to another one of our antitrust cases in the energy sector. In 2017, we had sanctioned again the incumbent EDP and the company Sonai for entering into a market-sharing agreement in the form of a non-compete clause in the context of a partnership contract. And Sonai is a major conglomerate in Portugal, active inter alia in retail distribution, telecommunications, media, real estate, and energy production. And we found that as a result of this partnership, Sonai was prevented from entering the electricity supply market for 2 years. And this occurred at a crucial stage in the process of opening up the energy markets, with the regulated tariffs for end consumers coming to an end after 2012. And General Rantos concluded that Sonai could be regarded as a potential competitor. And since the parties were potential competitors, the non-competition clause, which they had included in their partnership contract, should be seen as a market-sharing agreement. That is a restriction by object without the need to demonstrate harmful effects. We could have pursued this case also as an abuse of dominance by EDP to prevent market entry, but decided instead to assess it through the collusion lens, so on the basis of Article 101. So let's now wait and see whether the ECJ follows Advocate Branto's opinion. I hope so. I will stop here because I may have exceeded my time. Thank you.
Okay. Thank you very much, María Joao. In my dual role of moderator and speaker, I will explain one case of the Spanish Competition Authority. This is María Joao. So let's go to the Spanish Competition Authority case. It deals with Enel Green Power Spain, as you see, and I have included some slides in order to explain the facts of the case. There's, of course, a network of production of energy in Spain, different sources of production of energy, then the transport of the energy, and then going to the final consumers, domestic and industrial consumers. And I show you here the map of Spain with this network of transportation of energy in order to show you the nodes, because this is the relevant point for this case. The energy is put into the system by the producers using those nodes that are included in this map, and the responsible for this network of transportation and checking the capacity of each one of those nodes is Red Eléctrica, which is a public company in Spain. But during a long period of time, Red Eléctrica delegated certain functions on private entities. And then the thing is that those private entities had a particular function. The functions are, you have them there, it's administrative functions, only receiving the requests of capacity from different operators, and the designation of this private entity in charge of each one of the nodes, it's based on a timeline. So the first one that comes is the one that is designated the responsible for the node, and the thing is that they only need to receive the documents and send them to Red Eléctrica, which is the one that adjudicates the capacity in each one of the nodes. The thing is that we have a conglomerate of companies. This was relevant in the case in order to determine the responsibility of each one of the companies in this conglomerate. But the thing is that Enel Green Power was intended to poor energy with 3 projects that you have there. And those projects that are here, the names of the projects, were entering energy in the system. Let's see if it works. Through 2 nodes. The nodes are there, Tajo de la Encartada, and, which is in the south of Spain, and Lastras, which is in the middle of Spain. And the thing is that, and I included here those charts that come from the decision, the thing is that Enel Green Power was misusing the functions that they were delegated by Red Eléctrica Española, because instead of consolidating the requests of capacity, his own request, together with alternative requests coming from other entities, Enel Green Power was conducting some behaviors that didn't allow the competitors to enter in the market. So it was a case of self-preferencing in both of the cases. It was asking for guarantees to the other companies. It was not consolidating the requests. So the final result was that in these 2 nodes, the projects of Enel Green Power received capacity and the competitors did not receive capacity. And the interest of this case, well, it has lots of different things, but one of the most relevant points in this case is that the competitive companies went to the regulator in Spain, the energy regulator in Spain, and asked for help because there was a conflict of access. The relevant point here also is that we have a double capacity at CNMC because we have two different chambers, one of them dealing with competition and the other one dealing with regulation. So the regulatory part of the CNMC considered that the access was not correct, and the adjudication was considered void by the CNMC, the part of regulation of CNMC. And they reversed the situation to the previous situation, so the situation was they needed to recognize capacity to the competitors. The companies challenged the decision, the regulatory decision of CNMC to the court, and the courts confirmed the decision taken by the regulator. And the regulator, the regulatory side of CNMC, sent the case to the competition side of the CNMC. And then we conducted a case where we determined that there were 2 abuses of dominance based on those facts for self-preference of Enel Green Power Spain in relation to the other companies, and we imposed these 2 sanctions. As you can imagine, we faced several problems, like the determination of the market, because each one of the nodes was considered the market, and then there was considered 1 abuse for each one of the nodes, and also a consideration on double jeopardy that I think that was really relevant, considering the former, and recent case law coming from the Court of Justice of the European Union, and considering that regulation and competition have different objects and different interests to be protected, there's no double jeopardy, and then we imposed 2 sanctions of abuse of dominance because of this behavior. And because I am going to moderate myself in a strict way, I am going. Yeah, that's it. We are going to continue to the digital sector, and for developing new trends on digital markets, I'm going to first give the floor to our Indian colleague, Bidyadhar Majhi. So please, you have.
Yeah, thank you, María. At the outset, I would like to extend my sincere thanks to ICN community and Japan Fair Trade Commission for organizing this workshop and giving me this opportunity to be part of this panel. So I'll speak on the enforcement approaches of Competition Commission of India, particularly in digital market cases. I'll deal some issues and the cases there too. The Competition Commission of India has completed 13 years of its enforcement during last year. And during the formative years, we have had a steep learning curve. During initial years, we have cases from traditional sectors, including real estate, pharma, cement, tire, And what happened during recent years, there is a surge in digital market cases. So many digital market cases we are dealing, and the Commission has passed orders. And the cases pertaining to all verticals, be it platforms, be it aggregator, cab aggregators, be it online trading, travel agents, so on. So before delving into the issues, let me mention the relevant provisions of the Competition Act 2002, which deal with the unilateral conduct. So Section 4 of the Competition Act prohibits abuse of dominant position. And under this section, conducts such as imposition of unfair conditions, unfair price that includes discriminatory pricing and predatory pricing, limitation of output, denial of market access, and leveraging of dominant position. These conducts are covered under Section 4 of the Competition Act. And under vertical restraints, which is covered under subsection 4 of Section 3 of the Act, which prohibits the anti-competitive agreements relating to exclusive supply agreements, exclusive distribution agreement, tying and bundling, resale price maintenance. So having said that, let me come to my digital market issue. Let me take the issue of deep discounting. Deep discounting is nothing, it is a practice of selling of products or a service at a highly discounted price on the online platforms by the suppliers or the platform service providers, so that it becomes unviable for the offline traders to compete with them. So the Offline Traders Association, they came to the Competition Commission of India, and they filed a complaint against these online platforms that they are indulging in deep discounting. While examining the case, it's a specific case I'm talking about, it is a case on online travel agent platform, that is Make My Trip. The Commission recently passed an order against Make My Trip. The Commission make a distinction between deep discounting and predatory pricing. Deep discounting is related to a price which we call it as a maximum retail price. And your predatory pricing is related to your benchmark cost, average variable cost. So a product which may be deeply discounted, but an entrepreneur may sell it at a price which is above the average variable cost. So in that case, the Commission thought that indulging in deep discounting may not be an anti-competitive activity, whereas if it is selling at a price which is below average variable cost, then it can be considered as an anti-competitive. So deep discounting in the Make My Trip matter was not considered as an anti-competitive conduct. However, deep discounting along with other activities of the platform, that gave rise to building a case against Make My Trip, not alone the deep discounting. Let me come to my second issue, the price parity obligations. This is an issue that is coming up before the Commission in many cases, price parity. And price parity obligation, it may be in two forms, in the narrow price parity and a wide price parity. In a narrow price parity, the suppliers is restricted to put price below what it is showing on the platform. And in the wide parity, the supplier is restricted not to put the price on its own platform as well as the other intermediaries. In the same Make My Trip case, the Commission considered the price, the narrow price parity obligation is not anti-competitive because it has some efficiency justification, whereas the wide price parity was considered as a anti-competitive, and Make My Trip was held in that matter as indulging in anti-competitive conduct. Another issue is tying and bundling issue. Tying and bundling issue, in traditional markets, when a seller is selling a product as a condition of selling another product, so in that case, the consumer has an option to shift to other supplier or other traders. But in online market, the users in the digital market had less incentive or disincentive to move to an alternative because of the presence of status quo bias. And this issue we discussed in another matter. It is a food delivery matter, which is Swiggy and Zomato. Swiggy and Zomato, these are the two major food delivery platforms in India. And the allegation against Swiggy and Zomato was that Swiggy and Zomato, they are bundling their food delivery service along with the food ordering services. So food ordering is the platform service, and whereas food delivery is the service rendered by some others. So the Commission considered this matter, whether this is amounts to tying and bundling, but the Commission come to the conclusion that this is not leads to a competition concern in the market, because it leads to some efficiency argument. Because when Zomato ensures that a certain food delivery company will deliver on time, then ultimately it is standardizing its products and its branding also. In that way, the consumers are also getting quality products in that way. So in this case, the Commission found that the bundling of food delivery service along with the food ordering service is not anti-competitive. The next issue that was discussed in the previous section is the data privacy policy, or transparency in data collection and data sharing policy. That issue was discussed in a matter pertaining to WhatsApp. So the Commission in its prima facie order, what the WhatsApp used to do earlier, when using WhatsApp, WhatsApp used to ask the consumers to give consent for sharing data with his other company or for other purposes. But in 2019, what the WhatsApp did, they just changed its privacy policy. And when the consumer gives consent, ultimately the consumer data is shared with its partner company, Facebook. So that issue was taken up by the Commission, and while ordering for investigation, the Commission decided that this amounts to reduction in the quality parameters of competition, and the Commission directed for investigation. In this case, the Commission developed two theories of harm. One is the exploitative theory of harm, and another one is exclusionary theory of harm. And the Commission is of the view that when the WhatsApp is saying you have to share your information with the other company so that you can avail the service, it's the privacy policy as well as the terms and service was too broad, vague and unintelligible to allow user to make an uninformed choice. Also, users were not provided with appropriate granular choice to object to or put out the specific data sharing terms. The purpose of such sharing was found to be beyond users' reasonable and legitimate expectations regarding quality, security, and other relevant aspects of the service which they register on WhatsApp. Thus, the Commission was satisfied that the data sharing policy was amounted to degradation of non-price parameters of competition, wise quality, which result in objective detriment to the consumers without any acceptable justification. The Commission observes that the non-value, consumers value non-price parameters of services equally, if not more important than the price as a factor. So reduction in consumer data protection and loss of control over their personal data by the users was seen as a reduction in quality. And secondly, the Commission also in that matter held that when the WhatsApp sharing data with the Facebook ultimately the Facebook monetize its data. The targeting the consumer customize the data and they target the advertisement. Ultimately, when the both the company, Facebook and WhatsApp, they come together and they have the huge consumer data, it will ultimately exclude there is entry barriers in the advertising market. So in that way, so it creates a exclusionary barriers in the market. So that was the prima facie order of the commission. In that way, the commission directed the Director General to investigate the matter in detail. So another issue is self-referencing platform neutrality. Since the platform plays a dual role of a regulator of the marketplace as well as a competitor, the platform may have ability as well as incentives to discriminate players who list their products on their platform. This raises the concern of platform neutrality. And this case was discussed by the commission in a matter, Zomato and Swiggy matter that I discussed just before. And Zomato and Swiggy, they are imposing price obligation agreement, minimum business guarantee agreement, preferential listing in terms of advertising, etc., on the restaurant partners. It's because they are the platforms, and they are in the advantageous position. And another issue is multi-product ecosystem and exclusive tie-up. In many of the cases, exclusive tie-up have been seen in raising competition concern. But in cases like Amazon and Flipkart matter, many smartphone sellers, they came to the commission alleging that there is exclusive tie-up of a particular phone company or a particular product company with Amazon or Flipkart for exclusive sale. So commission didn't find any concerns of competition concerns if there is exclusive tie-up or exclusive selling of products. But exclusive selling of products along with certain other conduct, self-preferencing, deep discounting, that may create an ecosystem which may be considered as anti-competitive. Beside this specific issue, we have also changed our approach towards the defining relevant market and assessing dominance because of the increase in the digital economy and importance of data. Earlier, we used to define relevant market in silos. But in a digital ecosystem, you have to see the different parts of the market, different parts of the user. That we have the specific approach or the specific type of approach that is already in the statute book. We are not specifically following, and we are following in case-by-case basis, and depending on the size of the company and the data, network effect, and so other things in defining the relevant markets. And in the increasing number of contexts, access to data has become critical for the firms to compete and innovate. Data as a metric is increasingly assuming significance in every stage of competition assessment, right from delineation of relevant market to determination of market power in examining conduct and also prescribing remedies. To fully account for the magnitude of those novel factors, focus has shifted from price-centric factors to non-tangible asset factors like data and non-parameters such as privacy, innovation, and choice. The theories of harm and constitutive elements must have appropriately evolved to reflect the new and complex structural and behavioral dimension in digital markets. Another last point I just want to make is the multi-product ecosystem. I have already mentioned about this. So in a specific conduct of digital market also raises competition concern, but just like in exclusive tie-off and deep discounting, and some of this if you see in isolation, that may not fall under the provisions of the competition law. But if you see in as a whole, as a ecosystem, then we find in many of the cases like our Make My Trip cases that create a competition concern for the competition concerns. So that's all.
Thank you very much, Bidyadhar, for this comprehensive explanation. And I'm going to give the floor again to our Portuguese colleague, to María João. I don't know if we can see her. Yeah, we can. So, María João, thank you.
Thank you, Pilar. So we have been prioritizing digital throughout the years with a number of outputs. Inter alia, the unilateral conduct investigations we opened against Google in our tech markets and in the payment services sector, of which I'll be talking today. Our investigation of Google's behavior was triggered by a complaint lodged by our National Association of Media Publishers relating to possible abuses along the ad tech value chain, namely the markets for publisher ad servers and for supply side platforms. Ad servers allow publishers to manage and run online advertising campaigns, that is to define which ad space to sell and how to sell it. Ad servers connect publishers with ad tech intermediaries and ultimately advertisers, whereas supply-side platforms are intermediaries that sort the demand for ad space coming from advertisers, ranking bids for ad space through real-time auctions. And our preliminary investigation found that Google holds a dominant position in the publisher ad server market and in the supply-side platforms market in Portugal. And what is striking is that in these markets, Google plays both the role of bidder and auctioneer. And not surprisingly, we found evidence of self-preferencing behavior by Google at various stages of the digital advertising chain, including the so-called last look advantage, where Google's supply-side platform would be given privileged information about competing bids before making its own bid. So as a result, it could outbid competitors in every auction by bidding marginally higher than the highest competing bid. And this last look advantage was coupled with Google's ability to identify the auctions where competition was strong or weak. So this way, Google could pursue a dual strategy depending on the degree of competition in auctions, bidding more competitively where competition was stronger by charging just cents above the next best offer, and relaxing when competition was weaker by increasing its bid to earn a higher margin. And this obviously raised a strategic barrier against Google's rivals by reducing the ability of competing supply-side platforms to win auctions and by placing them at a competitive disadvantage. And as a result, Google may have prevented effective competition in the ad tech value chain. And moreover, this may also have affected the revenues and increased the costs of media publishers, including online press. That had brought us the complaints, so it cannot be excluded that this type of anti-competitive behavior could ultimately have an impact on media plurality and freedom of expression. Now, following the opening of our investigation, the European Commission informed us that it intended to extend the scope of its own investigation against Google to include the behavior and the markets that we were investigating. And as you may know, under the rules of the ICN, the European Commission, when the European Commission initiates an investigation, it relieves the national competition authorities of its competence to investigate the same fact. So in September last year, we closed our investigation and passed it on to the European Commission together with all the evidence and information we had gathered. Now, turning to the payment services sector, in July last year, we issued a statement of objections for abuse of dominance, this time against the domestic card scheme provider, which is a joint venture owned by most banks established in Portugal. And this joint venture provides a card payment scheme, processing services to card issuers and acquirers, and it owns and manages the largest ATM network in Portugal. And we found evidence of tying. Basically, card issuers and acquirers who wanted to have access to the card payment scheme were also required to purchase all or most of their processing services from this joint venture. Another interesting aspect of this case is the fact that the behavior we investigated, it may also entail a breach of the applicable financial regulations. There's an EU regulation which determines precisely the unbundling between the payment card schemes and processing activities, and the enforcement of this regulation is under the jurisdiction of the financial supervisor, the Bank of Portugal, and we are indeed working closely on this matter. Anyway, we believe that the conduct at issue raised barriers to entry to new players, including those based in digital technologies like fintech providers, and we find that it's key that incumbents do not strategically foreclose market developments and deprive consumers from the benefits that innovation and digitalization may offer. Thank you.
Thank you very much, María Joao. And now we go to Mexico and see what José Manuel tells us about COFECE. Thank you.
Actually, I would say that we share many of the cases that Portugal is carrying out right now. Currently, we have 3 ongoing investigations related to the digital market, 2 related to unilateral conducts, and 1 investigation on barriers to competition, which is some kind of, let's say, Mexican invention similar to the market investigation of the CMA authority. So these 2 investigations are related, one to the advertisement market, and the other one is related to the distribution of mobile applications and the payment method related to these services. Regarding our investigation on barriers to competition, we are analyzing the market, the e-commerce marketplaces, and something that is very particular to our jurisdiction is that maybe we don't have the issues that other jurisdictions are suffering right now regarding, this market power of Amazon. But we want to be sure that this new market is going to be work properly for the benefit of the consumers. Also, we have a case related to the card payment system. The discussion related to this case, it's pretty interesting because we are analyzing the case, and the decision of this case is not done yet, and it's about to be, we're going to have a final decision by the Board of Commissioners, but some of the discussion related is whether an ecosystem market definition is properly for this market, or maybe we should use a more traditional way to define the markets, like a single market platform or a multi-markets platform. So it's going to be interesting what it's going to be the criteria by the Board of Commissioners related to this case. And finally, I would say that we have also an investigation on the supply and distribution and retail sale consumers, in general groceries for consumers, in which one of the characteristics in this case is that maybe there is a presence of a gatekeeper in the market preventing the entry of new competitors. So besides the energy, we have also relevant experience regarding the digital sector.
Thank you very much. Thank you for sticking to the time also. And now we are going to our last sector of the session, that it's like the miscellaneous part. Let's see if it works. Where we will go back to Portugal because they are going to explain a part of, a study that they have conducted on the connection of inflation with competition. So, María Joao, can you please, in 3 minutes, talk a little bit about your study?
Well, not really.
Okay.
I was hoping to discuss another interesting development to look for in the near future, which is the interplay between the EU's Digital Markets Act and antitrust enforcement.
Okay.
And because Pilar, the DMA will be, as we know, an ex-ante complementary tool to the case-by-case antitrust enforcement work of competition agencies, and if it will not replace competition enforcement, which will continue and perhaps may even intensify, as we've seen, given the acceleration of the digital transition and the burst in e-commerce. I think the example I gave previously on the cooperation we've been having with the financial supervisor in the payment system case provides an example of the type of coordination we may have here in the case of the DMA, in the interplay between the DMA and antitrust enforcement. Because this will require an even closer cooperation between agencies to avoid, for example, conflicting decisions or remedies imposed on gatekeepers. And this is why, and I think this is also relevant, it's also related to the case, the ECJ case you mentioned before, Pilar, on double jeopardy. And this is why the DMA has included provisions meant to, foster such a coordination and on exchanging information between enforcers within the framework of the ECN. I think this interplay will be no easy task, but I do remain optimistic because the ECN has proven to be an effective forum for cooperation as a decentralized but articulated system of enforcement. And the previous example I gave on our investigation against Google, I think it illustrates this quite well. The fact that we're going to be part of the DMA enforcement process as a member of the DMA advisory committee, I think will also help, such as the fact that we will hold investigation powers together with other national competition authorities, because we'll be able to participate together with the Commission in inspections and interviews. Anyway, more broadly speaking, I think international cooperation and coordination are instrumental here to achieve a high enforcement standard in digital. That is to ensure that our antitrust decisions, either behavioral, structural remedies or fines, are truly complied with. In the EU, the ECN ensures this outcome, but I think given that the current level of substantive convergence taking place at a wider level, I mean, this panel shows that we're listening to the same type of policy statements. We're using kind of the same narrative, and for example, both Europe and the US are using a similar narrative. So we can say that the digital economy has sort of helped this international convergence, and I do think that we do need to work together if we want to ensure that people and businesses, either big or small, are able to fully seize the benefits of digital, so that new ideas and creations may flourish, so that people remain in control of their choices, of their data, and of their lives. Thank you, Pilar.
Thank you very much, María Joao. So now we go to Mexico, and I think we are going to talk about barriers to competition procedure, right? Okay.
Yes, right. We have a new procedure which is called in our jurisdiction an investigation on barriers to competition, which, as I was saying, it's pretty similar to market investigations. This concept of barriers to competition is some kind of Mexican invention in which we consider any structural or behavioral characteristic or even any kind of regulatory issue that could be preventing the competition in the markets. So the interesting part of these kind of procedures is that we are able to order any kind of structural remedy in order to improve the competition conditions in the market. And also something that is pretty interesting of this procedure is that we can also prevent any kind of process that could be lessening the competition in the market. So the interesting issue is that we could issue any kind of order to the economic agents in order to avoid any kind of anti-competitive behavior. And we're also, as I was saying, to order any kind of structural remedy. Until now, we haven't a case in this matter, but eventually I guess that we will be generating more criteria and more cases related to this. And finally, I would say that this tool is pretty flexible since we are able to use it on digital markets and also with traditional markets. For instance, we are in Mexico, we have tortillas, and we are analyzing one of these markets. We are using this tool in a market that is pretty relevant for Mexico, which is corn flour. So we are analyzing the characteristics of the market in order to improve the performance of this market in benefits for the consumers.
Thank you very much. So now let's go to India. So Bidyadhar, please tell us about the changes that you foresee in your system in the next years. Sorry.
Yeah. The Government of India has proposed for a major amendment in the Competition Act 2002, and the Competition Amendment Bill is now before the Parliament of India for consideration. And it's a major revamp is going to happen in the Competition Act, and many changes have been suggested, proposed in the amendment bill. So I'll discuss a few of them, the major few of them. So one is on deal value threshold. In major regulation, earlier we used to do based on asset and turnover criteria. And in the amendment bill, it is proposed that a deal value threshold, the additional deal value threshold of 20 billion US dollar is to be incorporated as an additional criteria for notifying merger and acquisitions if the target has a significant business operations in India. So presently the jurisdiction of CCI only meet the asset and turnover threshold, but in the new age markets, the entities, those who are operating successful business, they're gaining significant market position because of a huge number of data, growth and network effects. Such entities command a significant valuation if they have even if they have insignificant asset and no or insignificant turnover recorded in their financial statement. Thus, this criteria, deal value criteria, has been proposed with a view to bring high value merger and acquisition transaction to the net of competition law scrutiny. And the next is timeline of merger review. Earlier, that permit us to clear a merger deal within a time limit of 210 days, but now it is proposed to reduce it to 150 days. Even though that the Competition Commission has a self-imposed timeline of 30 days. During 30 days timeline, we are mostly clearing most of the merger cases. Another important proposal for introduction of a commitment and a settlement. Earlier, the Competition Act do not have any provision on settlement and a commitment. What happened over the years, many cases they went for litigation. They are lingering in various appellate courts. And considering that it is proposed to introduce a commitment and a settlement provisions under the Act. The settlement mechanism would apply to the alleged contravention of any anti-competitive agreement or abuse of dominant positions. And the application for settlement may be filed only after receipt of the investigation report from the Director General, Competition Commission of India, but prior to such time as may be prescribed by the regulation. and the commitments from the party to address the anti-competitive concern may be received during the investigation time. Another major changes, key reform envisaged in the bill is to do away with the requirement of prior approval of the Competition Commission of India in case of transaction involving open offer or acquisition of shares through regulated stock exchanges. It would balance the need for standstill requirements and a compelling element of a time sensitivity in the market purchases. In such cases, they need not come to the Competition Commission of India. And the bill also proposed to bring leniency plus. We have leniency provision in our act, but another provision, leniency plus, is proposed to be in the act. Under the leniency plus regime, if a cartel participant of a case give the information about its participation in other cartel, then ultimately that firm will be covered under leniency plus, and more reduction on penalty that firm will get in the current investigation. And there was no limitation period in the present Competition Act that anybody, the information provider, can file a case before the Competition Commission of India of a anti-competitive conduct that may be of 10 years down the line. To avoid that sort of uncertainty for the businesses, a limitation period for 3 years. That means that within three-year periods, if any anti-competitive conduct has happened, and the party can approach the Competition Commission of India, but after that, such conduct cannot be examined or scrutiny under the competition law. That is another proposal. So another important thing, the ex-ante regulation on digital markets. We do not have, India do not have any ex-ante regulation. So while considering this amendment proposal, the Parliamentary Standing Committee, they just identified a systematically, just a minute, systematically important digital intermediaries, and taking into account that the Government of India has established a committee on digital competition law, and the mandate of the committee is to examine the existing Competition Act, whether the problems arising out of the digital markets or out of the big takes, whether it can be covered under the existing competition law. If it is not covered under the existing competition law, then the committee is empowered to propose a new act, what it is termed as digital competition law. So that's all.
Thank you very much. So I will jump into two pharmaceutical cases of the Spanish competition authorities. I will be quick because we run out of time. Let's see if the slides work. Anyway, I will begin with a Lydian case, which is an abuse of dominance that was established by the Spanish Competition Authority, where we impose a sanction of 10 million euros, more or less, for excessive pricing. And it's an excessive pricing in a medicine that is intended to treat an extremely rare disease, which is XCT. It's so strange that you see that the number of patients that are affected all over Europe is really low. And this is a medicine that it's really relevant for the patients. The slides are not working. Because it slows the progression of a chronic disease that creates really serious problems on patients. The thing is that Lydian has been the exclusive distributor of the drugs based, let's say, on this substance, which is CDCA, and they were exclusive distributors since 2010 with two different names of the medicine. And they also obtained the exclusivity of this supply of the active substance in which the medicine was based. The point is that they were able to put in practice a very long and sophisticated strategy in order to first become monopolists of the product in Spain. They acquired the competitors, then they reached agreements with research centers in order for the research centers not to be able to work with other companies in order to receive all the data that are relevant for the treatment. Then they reach an exclusivity agreement with the producer of the active principle, of the active substance. They even challenged the possibility of creating master forms that was an option in other countries and was for a little while an option in Spain. So they obtained a situation of monopoly, and they were able to obtain an administrative decision that implied that the medicine was an orphan drug, and this has lots of administrative implications in our market, because this is a case that has been solved in the Spanish Competition Authority, but very similar cases have been solved also in Italy and in the Netherlands. But we consider that the markets are independent because of the legislation. The legislation is really different in one country and the other, so the barriers are absolutely different. And then we consider that we had national markets in this case, and they created a new brand. So with this strategy, they were able to increase the price of the CDCA Lidiant in an incredible way that you see right there. So we were able to determine that this was excessive pricing. You see that the increase was absolutely amazing. And then we determined two different exclusionary behavior and exploitative behavior. Exclusionary behavior because of the exclusivity agreements with the reference medical centers, and especially for the agreement with the active substance producer, and the exploitative behavior, of course, first of all, because of the price that what they were charging to the social security system in Spain, but also because they conducted some behaviors of delay in the internal production of the product, so they were able to import the product coming from a different European Union country, considering that the production was happening in Spain, which is something absolutely incredible. And then because of certain behaviors that they conducted in the negotiation with the Spanish social security system. So another relevant point of this case is that we, together with the sanction, imposed remedies, and we imposed an obligation to commercialize the product with no excessive price, which is something not evident, but there was an agreement between the company and the ministry, so this was considered at least like the beginning of the price that they should respect, because they were charging different, I mean, a much higher price, and also an obligation to raise the exclusivity clause in the contract with the producer of the substance. So from our perspective, the sanction is of course relevant. The deterrence element is also we need to take it into consideration, but the obligation of raising the exclusivity clause is really relevant from our perspective. From our perspective, considering that we in the former years impose a banning of the companies that have been determined responsible for infringements, competition infringements, the banning of contracting with the administration. In this case, there's a big problem with this, of course, because they are monopolists offering a very relevant medicine product for the social security, so we recommended the administration not to impose the prohibition in this particular case. Then I'm going to very quickly mention the other case that we had, which is this case of sham litigation that our director mentioned this morning. In this case, we are talking about two different rings, and the thing is that one of the rings was protected by a patent, and there was another ring, another company that was introducing a new product in the system. Again, the slides are not working, so I was trying to show you the different products, but the thing is that the question was whether or not there was a breach in the patent with the new product towards the former one. So let's see if now you see them. But then the facts were that the company that was in power of the patent was aware that because of the technicalities of the new product, there was not breach of the patent. We conducted downgrades, and we also made an investigation that showed in a clear way that they were absolutely aware that there was no breach of the patent. They were able to access to the new product because it was sold in a different market. So we were able to prove that this request that the company did to the court in Barcelona in order to paralyze the entrance of the new product in the market and to paralyze the manufacturing of the product was invoked to be based on the patent right, but in fact had a different reason. The reason was that they needed to slow or stop the entrance of the new product for a short period of time, but it had relevant implications in the market. And then we considered proof that this was some litigation, and I included here, I will not have time to read it, of course, but perhaps you can at least take a look at those things that I underlined. This is a part of the decision taken by the court that considered that the company was lying to the court when asking for the interim measures, and this was something that we consider really relevant in the decision making of our case. And then we go to Q&A. So we have 3 minutes for Q&A. Are there questions from the floor? I don't see anything written online. So let's go to a question for José Manuel, for example. So could you share with us some of the challenges that COFECE is facing regarding digital investigations?
Yes, I have a couple of cases that could be interesting. The first issue is that for some jurisdictions, it's almost impossible to gather information, since sometimes the argument of the competitors is that the company is not based in Mexico, so the information is not here, so it's impossible to gather this information for you. And maybe the second challenge that we were discussing along these days is that sometimes we could have several theories of harm related to digital markets. Sometimes we are able to gather evidence, but the issue is transforming this evidence into a good a statement of objections in order to convince the judges. I guess that eventually for some jurisdictions that are new in the case of digital markets, this is going to be the challenge to convince the judges in order to prove that any kind of behavior is lessening the competition.
Okay, thank you very much, José Manuel. Perhaps María Joao, considering that she woke up so early, can you tell us, María Joao, how are you using artificial intelligence techniques to detect anti-competitive behaviors in the former years? Can you explain in a minute this easy question?
You have 1 minute.
We cannot
You are
hear
muted.
You. Yeah.
Sorry. Yes, 6 a.m. It's easy. So we have indeed been using AI techniques such as web scraping and other screening tools to help us detect anti-competitive behavior in digital markets, notably algorithmic-led collusion and resale price maintenance, because e-commerce has significantly reduced search costs for consumers. But the transparency of online prices has also made it easier for firms to monitor each other, and it may, for example, help suppliers enforce RPMs downstream. But fortunately, these same tools can be used by us to detect anti-competitive behavior. And this allows us to assess the relevance of complaints we receive in the context of e-commerce, so to sort out indicia or evidence that is less likely to be viable from indicia that deserves further attention, further action. For example, once we receive a complaint alleging an RPM in e-commerce, we can take a first look on its potential within hours, the time it takes to collect the data. So the good news is that these tools are not very time consuming. It's the miracle of AI. It's about giving a few parameters to the code and then running it. So it allows us to allocate our resources more effectively. How does it work? Web scraping involves extracting pricing data in an automated fashion from online stores, marketplaces, price comparison websites, and converting it into readable formats. After collecting the online pricing data, we apply a screening technique to confirm whether the results are consistent with an antitrust theory of harm, for example, RPM, and this is also done automatically in a matter of seconds. And if we find sufficient hits of price alignments, we may deem a complaint worth further analysis. And by using this tool, we have obtained so far 2 search warrants and opened 2 investigations on RPM in e-commerce relating to the supply of pharmaceuticals and food supplements, one of which was already successfully concluded through a settlement. So this is, of course, another example of the proactive methods of detection we've been using throughout the years, and it shows how we can also take advantage of AI to boost our enforcement. Thank you.
Thank you very much, María Joao. So for the sake of respecting time, we are going to finish here. Arigato to my colleagues and to you for listening to us, and of course to the Japanese Competition Authority for having us today here. Thank you.
Thank you.
Thank you very much.
Another exciting news.
Now we move on to closing session. Mr. Yamamoto and Ms. Canedo, please come up to the stage. Ladies and gentlemen, we have reached the end of this workshop. So now I'd like to invite Mr. Takashi Yamamoto, the Commissioner of JFTC, to deliver his closing remarks. Mr. Yamamoto, please.
Good afternoon, everyone. The 2023 Unilateral Conduct Workshop is coming to an end. During the 2 days, I had attended several sessions online. I'm delighted to see active discussions in each session. In closing this workshop, I would first like to thank co-chairs, the French Competition Authority, Autorité de la Concurrence, and the Spanish National Markets and Competition Commission, CNMC, for their great cooperation and useful advice in preparation of this workshop. Thanks to both authorities, the content of this workshop was rich and the discussion became very fruitful. And my sincere appreciation also goes to the moderators and speakers who participated in each session. I heard that you prepared carefully in deciding the structure and content of each session and provided very informative, and meaningful comments in each session. Furthermore, I would like to extend my gratitude to all the participants in this workshop. I'm deeply grateful for active participation from the floor. Your active participation was essential for the success of the workshop. Although this workshop is now over, cooperation between competition authorities in enforcement and policy making will continue. As stipulated in the ICN operational framework, the nature of the ICN is an informal network between authorities. And the workshop practical meetings attended mainly by working level officials and practitioners. Therefore, I expect that the participants established a personal relationship over the lunch or dinner, in addition to the significant discussions in each session. I believe that building personal relationship will help us to overcome the challenges in convergence of competition law and policy in the future. And I hope that this workshop, this short duration of 2 days, has provided a forum for future cooperation between us. Finally, I'm honored to inform you that the next ICN annual conference will be organized by our co-chair colleague, Spanish National Markets and Competition Commission, CNMC. It will be held in October this year in the beautiful city of art, Barcelona. I wish the Barcelona annual conference will be held successfully. I also hope that we can strengthen our close relationship built in this workshop and develop cooperation through international network at the annual conference. I would like to conclude by wishing all of you returning home with good memories of Tokyo, and I look forward to seeing you again at other ICN events. Thank you very much.
Thank you, Mr. Yamamoto, for your speech. And now, please join me in welcoming next speaker, Ms. Tierno, Director General for Competition of Spanish Competition Authority. Ms. Tierno, you have the floor.
Thank you very much. Thank you. Arigato, Mr. Yamamoto. First, I would like indeed to thank the Japan Fair Trade Commission for successfully delivering this 10th ICN Unilateral Conduct Workshop. It has been a pleasure to participate in this event. I think that we have been going through 2 inspiring days here in Tokyo, and it was really interesting, not just for us being present, but I think also for those who were joining us online for the plenaries. In this workshop, we had the opportunity to foster interactions and exchange insights with different participants regarding the developments and challenges of competition policy and its application in this area of unilateral conduct, especially in a digital market environment which poses pressing competition concerns for agencies to address. We have seen that it is necessary to reinforce coordination and exchange of experience and knowledge to bolster synergies and avoid creating conflicts in approaches. And it is important to check whether there are complementarities amongst us and to identify best practices within the main models and paradigms. I want to praise the ICN convening power, and in particular the leading role of the steering group, stewarding the ICN and each individual effort to make the ICN the top international forum for competition issues, at least for agencies. Within this network, the working groups play a key role moving the ICN forward. In particular, I want to thank the JFTC and the Autorité de la Concurrence that welcomed the CNMC this year as co-chairs of the Unilateral Conduct Working Group. And this event is the best evidence that the ICN is a relevant organization for us. And I will not break the news because this has already been said, but I want to take this opportunity to invite you all to the 22nd annual ICN conference that will be hosted by the Spanish National Markets and Competition Commission in Spain, in the city of Barcelona, from the 18th to the 20th of October 2023. The ICN annual conference is one of the organization's flagships, and it constitutes the focal point of the ICN's activity. Hosting this summit in Spain is an opportunity, and we will contribute to highlight the work of competition authorities in the international scene and the line of cooperation with other authorities with whom we face the same global challenges and difficulties. This will demonstrate our continued commitment to competition values and to cooperation. After these workshops so efficiently organized by the JFTC, I can see the challenge to meet your expectations, but nevertheless, I assure you that we will do our best. So to encourage your participation in the ICN annual conference in Barcelona, I think I can briefly refer to Barcelona as a city that is one of our top touristic cities. It's the second largest city in Spain. It has a privileged position close to, at the seaside, at the Mediterranean Sea, in the northeastern coast of the Iberian Peninsula. The city is full of light and of culture. Spain is known for its gastronomy. So this vibrant, modern, and welcoming city and history is linked to the development of trade and businesses and even the nascent stages of competition law. So that is why we have chosen within Barcelona in particular La Lonja, the Loggia de Mar, which is a building that stands for more than 700 years of history, where you will be hosted, where economy, culture, and architecture merge in a single space. And it is located on the seafront, in the heart of the Barcelona's historic center. It is one of the most significant and splendid buildings representing the city's economist and a culture. It's actually a monument. The Loggia de Mar has witnessed key moments of the history of the country and the mark of renowned figures such as the Colón family, the architect Gaudí, and the painter Pablo Picasso. In the 14th century, the Loggia was the trade or commerce court, and soon its jurisdiction was also extended to land affairs. So I hope this ancient and inspirational space can act as a spur for cooperation and steers us to hold competition discussions in a compelling and motivational way. Of course, we will be discussing most of the questions that we were debating here, but also everything else on all other topics of competition of the different subgroups. And precisely, the ICN members are currently reflecting on the topics. So I encourage you to reflect on them and to try to get your preferences across so that we can consider them. So do that to the co-chairs. The ICN depends solely on the voluntary input that each of us is making. So we really encourage you to do this. And thanking all the participants, what I want to do now is to giving you the opportunity to watch this video of Barcelona and the venue. Thank you.
It would be an honor to host the next ICN annual conference. We look forward to sharing ideas, experience, and strategies so that together we can overcome the future's challenges. Barcelona is one of the most dynamic and beautiful cities in the world and will give you a most warm welcome. Nos vemos en 2023. Moltes gràcies i benvinguts.
Thank you, Ms. Tierno and CNMC for this beautiful video. Ladies and gentlemen, this concludes the 2023 ICN Unilateral Conduct Workshop. I hope you found each session interesting and informative. Just one more thing to add. Following the ICN workshop, Competition Policy Research Center of JFTC will host an open seminar today at 5:30 on this venue, 4th floor. So the theme of the seminar is addressing digital markets, developments in Japan, the EU, and the US. If you are interested, please join us. So, please enjoy your rest of stay in Japan, and we see you all again in near future. Thank you very much. ありがとうございました。